This week is the final week of civil. You remain with 2 weeks. Next week, as we go on. So as I told you last week, use this week to revise civil. Unlike criminal, that when you're doing appeals, you are likely to go back. You get it? But civil now is different. It's not like criminal. Okay? So the touch is a bit different. And this week, it has a thin line of all the remedies. Okay? Era netutamu netubisoma nga byonna olaba review. Netutamu netubisoma ng'era olaba revision. Omuntu omutali musango.
I bought a paper of 20.
You see that you've been complaining about this high. Now this Friday. Yeah. This Friday, and the chances are high you have a number in your exam, the final exam from this week also. Okay? Chances are high that number is there. Hello. Yes. Okay, notify on WhatsApp. Okay, so just know this time round, concentrate those few things. Give for your life. On that we have in an order. We have appeals from orders. They give you an order, you have to ascertain whether it is an appealable order or you have orders we don't appeal against automatically. When you have first sitting of order. So once I give you the order, ascertain which order is it appealable. That's why this time round, vidala mukko katono. Okay? Vidala mukko katono. So you need to take time, and we appreciate this. And what I assure you, you're complaining about the workshop that it's huge. What if they give you the exam of that volume? So chances are high you're going to define exam, which is a total bulk, and she's capable of everything. Okay, so now this is a week of what we said that civil is also a procedure course unit. The procedure is, one, we first identify a client is before you, and we've said that this client has come seeking for legal redress. When a client is before you, first things first, conduct what we call a client interview. In your client interview, we know the things we look for. We said they are under Order 9, Order 7 Rule 1. Okay? Look at the cause of action, look at the parties, look at jurisdictions, look at locus standi, look at capacity to sue, etc. Okay? Look at the appropriate mode of instituting or commencing a suit. Then after conducting that client interview, then check on instructions. Okay? After taking on instructions, issue what we call a pre-action documents, what we call a notice of intention to sue. So the presumption is you differentiate between a notice of intention to sue and a statutory notice. After issuing that notice and the parties do not respond, then you are at liberty to proceed and institute a suit. So you go to what we call modes of instituting suits. We have a plaint, which is ordinary and then special endorsed. We have notes of motion. We have chamber summons, originating summons. We have a memorandum of claim, we have a complaint on oath, we have a petition, etc. At this time, the presumption is you know all the modes of commencing suits. Nobody you can tell that this is the mode. Okay. Then after that, once you've drafted, then look at the procedure of instituting the suit. Okay. Then go and pay the necessary fees. After paying the necessary fees, it's a case-to-case basis. We have physical filing and then filing electronic. Then after filing, appreciate the remedies within that period. After filing, we have what we call amendment of pleadings without leave. Okay, so appreciate how a plaintiff can make. So the presumption is you know the rules governing amendment of pleadings at that period. Okay, then after we have what we call interlocutory applications. Under this we have temporary injunction, whatever the case may be. Okay, then after those, then we go for what we call service of summons. Okay, the presumption is at this point of time you know the rules governing summons. Okay, you know what we call expired summons, you know what we call problematic summons. How do we deal with those summons? Then you know how we make an application for extension of time, substituted service, etc. Okay, then we also have what we call other remedies of the plaintiff upon institution. That is what we call attachment before judgment. You look at it and appreciate. Then after that, we presume you have served. After serving, the other part is supposed to respond. That takes us to what we call defenses. The presumption is you know all the different types of defenses. Defense with a counterclaim, a defense with a set of, a sham defense, a plausible defense, etc. Okay, so the presumption is once you are given facts, you can tell that these facts need a counter claim. It may be a counter petition, whatever the case may be, because you may petition when you also have a counter claim. So the presumption is you know the rules. Then after the same has been served, the presumption is that process is known as exchange of pleadings. The presumption is you read, stop and see, and you appreciated the entire process. That's the presumption. Whether it is a rebuttable, God knows better. Okay. Then after exchange of pleadings, we go for what we call summons for directions. The presumption is you know what amounts to summons for directions, who's duty to extract summons for directions, within what time frame. Okay, and the impact of failure to extract summons for, they can give you when a matter proceeded without summons. Okay, then within that period we have what we call withdrawal of suits. Okay, what is the effect of withdrawal of suits? What we have withdraw by consent, okay, and withdraw by application by leave of court. So it is a case-to-case basis. The presumption is all those things we are good to go. After that, we have what we call the concept of case management. This calls what we call consolidation. We have test suits. We have dismissal for want of prosecution. We have locus visit, etc. Whatever the case may be. So the presumption is all of those you know how to deal with them. Okay. So then after we are done with summons for directions, we shall go for what we call scheduling conference. Okay, where we come up with conferencing notes. Under this, we presume that you know the rules governing framing of issues. How do we frame issues? The presumption is you know the power of court in regards to framing of issues. All of those are presumptions. Okay, so I don't know whether they are rebuttable presumptions or not. Okay, so after all that, then the suit shall be set down for hearing. But at that point, the following things should be into your mind. Procedure where plaintiff only appears, and procedure where the defendant does not file a defense. So you should differentiate facts that call for proceeding ex parte and then facts calling for default judgments. That's the presumption. Then after, we set a suit down for hearing. Under hearing, this is where we call it leading of evidence. The presumption is under that you know what we call the burden and standard of proof. You know all the rules of evidence and then how to make submissions on each and every cause of action. And under that, you know how to respond. That's what we call prosecuting and opposing. That is the presumption. And under that, the presumption is you know all the categories of evidence that are supposed to be dealt with and the rules governing them. Okay? Then after that, when you've made submissions, then we shall go for judgment. Then that takes us to what we call types of judgments and contents. We have a default judgment, we have a judgment on admission, we have expert, we have interlocutory judgments, and then ordinary judgments. At that point, after court has entered the judgment, we look at what we call effects of the judgment. Under the effects, we have what we call execution. Okay, so the presumption is order 22. Wajisoma nojivako nojiteka wali. Okay. So at that point, we need to ask judgment date and judgment creditor. You have to appreciate the different modes of execution. Under what circumstances we go for this mode? What remedies are available to judgment data and judgment creditor? That talk brings in what we call stay of execution. And then what other mode? What other remedy? Objector proceedings. Look at stay of execution in two categories. That is to say, execution, stay of execution pending what we have today. Okay? Then stay of execution pending a civil suit between a judgment data and a judgment. Then look at other remedies, transfer of a decree, okay, where you can execute from other jurisdictions. The presumption is to change your gerako or man. Okay, so now at this point, okay, judgment has been entered, and the rule is once court pronounces it so, judgment is binding until it is set aside or varied. So under that, we have some remedies that you already looked at, what we call setting aside. Under order, that's rule 12 and rule 27. The presumption is you differentiate those rules more than nothing. Okay? Then after that, we go to what we call post-judgment remedies. This includes review, revision, appeal, and slip rule. That's where we are today. But the presumption is because you can't go for appeal, review, revision, or slip rule when you don't understand the entire procedure I've just mentioned. Because that's how you're going to get the grounds of appeal. Okay? So, are we good to go with commence? Simple embarrass. Kale, tukwate act. Someone with the Civil Procedure Act. What act? Someone with the Civil Procedure Act. Now, the technique is like this, okay? These remedies are hard to differentiate. That's the naked truth, okay? But we have those few things we can look at and conclude that yes, this is the remedy. Okay, this is the remedy. Whenever you get the question, okay, first look at those key requirements. Okay, so what should we start with? We start with the review revision.
Why don't you for the workshop cancel? Hello? We for the workshop.
Okay, let's start with the review. Let's start with review. Let's go to section 82 of the Civil Procedure Act. Section 82 of the Civil Procedure Act. Hey, you're going to look for grounds of review and revision. Let's look at section 82, review. Okay, section 82 says, okay, section 82 says any person, I want you to listen to these remedies, okay? Whatever remedy, you first ask yourself, who can apply? Okay? Section 82 says, review. Any person considering him or herself aggrieved, we first start with that. Who has a right to apply for review? An aggrieved party.
Councillor Rachid,
okay?
section 82 of what?
The Civil Procedure Act.
Thank you.
Okay, so the person who has a right to apply for review is an aggrieved party. Okay, it says a person considering him or herself aggrieved by a decree or order from which an appeal is allowed by this act, but from which no appeal has been preferred. What does that mean? You have a right of appeal, but you don't want to go for appeal. That's the first understanding. Okay, so that means once you get confused somewhere, yeah, you get it, because you can go for review even when you have a right to. That's the first requirement. That's the first thing you need to know, that the biggest challenge is choosing between review and appeal. We are going to kick out revision at a given point. Okay, we go on. Then, by a decree or order from which no appeal is allowed by this act. So, where you also see that you don't have a right to appeal, once you open like this and you see you don't have a right to appeal, how? The consent judgment. The answer is, once you open and you see consent judgment, the answer is review. No, right? Because we don't appeal against the consent judgment. So that's the first. So once you open, even if you have a chidala, no lava consent judgment, go for review. Automatically. So now in your workshop, there is a part where they gave you a consent judgment. So just go on that part. Even before we do anything, you write. You've gotten the remedy. Okay? Yeah, I already saw it. Okay? It is there. Yeah, I know. Huh? Go to workshop 1, parts. Go to appendix 4. So the question that applies to appendix 4, that is the answer. To be someone. Okay. Yeah. The people opening pages. Funtisa. And we are going to read to make matters worse. Okay. So we go on. We go on. We go on. Then it says, by a decree or order from which no appeal is allowed by this act. So we've said the first catchword for you to understand whether the answer is review. First open, you see whether you have a right to appeal. We shall see how we determine whether you have a right to appeal. Once you see that you have no right of appeal, don't make an application for extension of time within which to lodge the appeal. Go for review. Okay? I'll tell you the reason. Okay? Then says that by which a decree or order from which no appeal is allowed by this act may apply for review of the judgment. Okay? You may apply for review of the judgment. Now, where do we apply? Where do we apply? Okay? Where do we apply? Says to the court which passed the decree. Okay? To the court which passed the decree or made the order. So what does this mean? Review is available for both the magistrate court and the high court. Okay? Why? Once you see the judgment like this, okay? Once you see the judgment like this, and it is of the magistrate court, and you open when it is a consent judgment, or when you don't have a right to appeal, you go for review before that very court that passed the judgment. Okay. So are we together? Okay. Then let's go on. Now, when you read this, okay, does the law provide for grounds of review? Which grounds? Huh? So now, the act does not expressly tell you what are the grounds of. So let's go to the rules. Someone with the rules? No. It is order. Yes. Let's go to order 46. Okay. Order 46. Are we there? Members online, are we at order 46?
Yes.
Yes, are we all there at order 46?
Yes, please.
Okay. Order 46 says application for review of judgment. Okay. It says The extension is the easier one. You go. It says, a person considering him or herself aggrieved by the decree or order from which an appeal is allowed, but from which no appeal has been preferred, or by a decree or order from which no appeal is hereby allowed, and who from discovery of new and important matter of evidence, which after the exercise of due diligence was not within his or her knowledge or could not be produced by him or her at the time when the decree was passed. Now, the first ground, okay, the first ground is that you have to go for an application for review where you have discovered new and important evidence that was not within your knowledge. Okay, that was not within whatever the tenants agreement. Okay, so we go on. Then another ground, or on account of some mistake or error apparent in face of records. Now, that's why another challenge comes in. What amounts to an error apparent on face of Kebaita? There is a case of Justice Mubiru that clearly defines what amounts to an error apparent the face of records.
No, cash.
So we have famous cases that have defined an error apparent on the face of record. We have one here, which is a recent case. It is a decision of it is the case of Elias Kakoza and others versus Ahasiwe Stephen and others versus Ahasiwe Stephen and others. It is there you go. It's a new case. Okay, it is miscellaneous application number 01 of 2022. Okay. You can, I think on your reading list you might have this case. You can also read the case of Busoga Growers Cooperative Union versus Nsamba. Then, if that one doesn't work for you, we have the most famous case of FX Mubuke versus UEB. Okay, High Court miscellaneous application number 98 of 2005. It's the most famous case. It is called FX Mubuke versus UEB. It is case number 16 on your reading list. It is the most famous case that all lawyers cite when they are going for review. Because in that case, court gave considerations, okay? Court gave considerations and said that the meaning of an error apparent on the face of record means an error any reasonable person would see. Any reasonable nga nawe ne bwoba tosomanga ku mateeka oganaki. Yes, it has. The case of FX Mubuke versus UEB High Court Miscellaneous Application number 98 of 2005. Okay. Then I'm sure I also have the case of Rina Chivugo Chemist Uganda Limited, number 13. So those are the locus cases in regards to review. So those cases, they vehemently discuss what amounts to an error apparent in the face of record, discovery of new important evidence. And the last ground, because the law has given us only 3 grounds. The first ground is a discovery of, if that one is not there, we have an error apparent on the face of. If that one is not there, we have any other sufficient cause or reason. Okay, and it's also dealt with in that case. Okay. So now, where they give a consent judgment and one of the parties was not involved, it amounts to sufficient reason. Okay, it doesn't fall within the first one, but it is a sufficient. Okay. We proceed with our rule. It says that sub-rule 2, it says a party who is not appealing from the decree or order may apply for review of the judgment notwithstanding. Listen, a party who is not appealing from the decree of any order may apply for review of the judgment notwithstanding the pendence of an appeal by some other party, except where the ground of the appeal is common, the application and the appealant, or when being responded, he or she can present to the appealant court the case on which he or she applies for review. What does that mean? If judgment is entered against me, okay, or we are numerous parties in this matter, okay, we are 4 defendants. Then me, I prefer an appeal. Okay? When is the second defendant, he can apply for review, regardless of the pending appeal lodged by me. Okay? So it is order 46. Okay? Rule 1, sub-rule 2. It says, okay, this interpretation, where judgment is entered, okay, and I have made I can make an application for review, regardless of a pending appeal by another party. Okay. Now let me tell you, this case, the application for review, it says who can apply. That's where we started from. Any agreement. So I may be not a party to a suit. That's the catch word. But I am aggrieved. Okay? That's why this treatment is, in most cases, lawyers don't go for it. They go for it. Because one, review has no time. It is open. Because you look so bright, you are out of time. But let me first make an application for extension of time. So you get it. So, but when you read Order 46, Rule 1, Sub Rule 2, it is very clear that the only circumstances where the application for review may not be allowed pending an appeal, where the grounds of appeal are the same as the grounds of review. That means the outcome of the review will affect the appeal. But where the grounds of review are different from the grounds of appeal, you can proceed with the appeal. I proceed with why? Appeal is only available to a party to a suit. So now with third parties, we are just aggrieved by the decision. Okay? We are just aggrieved. For example, she owns land. Okay? She sold to me land. She comes out claiming that that land is for her late father. She sues her. You get it? Okay? Then court passes judgment. But when she sold that land to me. The outcome of this judgment is going to affect my interest. You get it? I was not a party to a suit. The matter is concluded. And the court has entered judgment against, and that judgment is there. She's going to work with that judgment. I will have sleepless nights. I was not a party to, but I am aggrieved that this order is going to affect my interest. Why? I am a bona fide purchaser for value without, so I can apply for review and it is set aside. So it applies even to third parties, not only parties to a suit. Okay? That's the first thing you have to note. Okay? Oh, those are in execution. Okay? That is execution. Okay? So we go on. Now, members, let's come back. Okay? The workshop is huge. The quarter and time is running. Okay? Then, the law has told us that where do we make the application? The application is made to the court that first. Now, that thing has different interpretations. Why and how? In most cases, when you look at such scenarios, what if the judge that passed the decree is no longer in existence? Okay? Who else will be available in such circumstances? Okay? Who will be available in such circumstances? Yes? So that's the meaning of court that passed the decree. So we have to read and understand, okay, what amounts to court that passed the decree. Okay? So let's proceed. Order 46, Rule 2. Order 46, Rule 2. It says, for whom application for review may be made. An application for review of a decree or order of court upon some ground other than discovery of new and important matter of evidence as referred to in Rule 1 of this order, or the exercise of clerical or arithmetical mistake or error apparent on the face of record of the decree, shall be made only to the judge that made the decree. Okay? Only to the judge that made, only to the judge that made the decree. Yes? We are going there. Okay. When you go to rule 4, it says application for review to be to the same judge or judges. Where the judge or judges or any one of the judges who passed the decree or made the order, a review of which is applied for, continues or continue attached to the court at the time when the application of review is presented and is not precluded by absence or other cause for a period of 6 months next after the application for considering the decree or order to which the application refers. The judge or judges, any of them, shall hear the application and no other judge or judges. So what does this mean? One, the application should be heard within 6 months. That's the period. Once you file within 6 months, okay, that's rule 4. Okay, but now when you look at this rule has exceptions where the judge is transferred. Okay, you just apply to that very court. The judge who is there will handle.
So technically, you apply
to the court that passed. That is the technique. Okay, so if the judge that passed the decree is not there, the predecessor or the success of that office may determine the application. Don't you know? Yeah, I don't know any judge under that category. Okay, so now briefly, that is review. Okay, so now the catchword of review. These are the following characteristics. The things you're going to look at and you say no. The neighbor you go for, you don't agree. I'm telling you. One, where the client before you is not a party to the judgment, because they always attach the order or the decree. So if the client before you is not a party, the answer is because that remedy is available even to third parties. Okay, that's one. Then two, where you don't have a right to appeal. Yes, where you don't have a right to appeal. We shall see how you determine, because they may give you an order where an appeal is not allowed, because you know we have a section and the rule appeals from orders. You first read all those orders. Imagine what you want them nakwangula kaliko order nojja nogikebe oyina soka zonna osomozi maga ejayo oba tejayo. You will appeal on an order which is not appealable. Ozirike luno kyona tukiveeko. Life continues. Okay, so when you look at, and then once you open, okay, now this is where the confusion comes from. Review can be made to any court, either magistrate or high court. Okay, that's the most challenging thing. But once you see that you don't have a right to appeal, you go for someone has logged in here. Okay, we proceed. Or we first read the facts of review. No. Let's go for revision. Let's go for revision. Members, let's deal with our points quickly. Let's deal with our points quickly and come back. With our points, those who are silencing them, let us handle the same quickly. Okay? We want to go for revision. Members, let's get back, okay? Members, are we done? Okay, let's proceed. Revision. Revision. Yes. Okay, yes. Once you see that the client, once they give you the judgment, first open the front page. Okay, they give you the order or the decree, whatever the case may be. Okay, look at the front page, look at the parties. Come to the question, who is before you? When you see that the person before you is not a party to the matter, you go for review first. Then if not that, you open at the last page, you look at the date. If you are out of time to appeal, you go for review. Even if when you are a party to a suit, you go when you are out of time. If not, when they say order, look at the law where that order emanates from. You first ask yourself, is this order appealable? Let me first sort that out. Okay? Let me first sort that out. When you look at order 44, okay?
Yes.
Order 44, it says appeals from orders. It says an appeal shall lie as of right from the foreign orders under section 76. Olaba order erina orders impitirivu muganda wange oziraba? Yes? No, we are saying we are looking at council was asking the things you look at and that I want me to more clarify on the things you look at and you said it is review. We said one, when you are at a hard part. Then two, when you don't have a right to appeal. And we say the circumstances under which you tell that you don't have a right to appeal. One, when you are out of time. Then two, where the order you have is not appealable. Not all orders you can appeal against them. So they have told you under order 44 that appeals from orders. Once they give you the order, first ascertain the order is emanating from what law. Because all the orders upon which you can just appeal are under order 40, for they are listed down. They are many. Okay? So if the order given to you doesn't fall under these orders, you don't have a right to. Okay? Now where the challenge is, you people may not be able to read these orders, you understand, over where you get it. But when you look at for example, an order under Rule 10 of Order 7, okay? An order, okay, under Rule 10 of Order 7, okay? Returning a plaint to be presented to the proper court, okay? Then an order under Rule 23 of Order 9. That's it. Setting. Which order is that? So you get it. So you keep on reading, you ascertain the order I have. We have now, for example, we have an order under Order 19. Okay? Under Rule 19 of Order 16. Amendment of pleadings. That one you can't. So you just go on reading and answer, okay? So if the order granted does not fall under these orders, my dear, you don't have a right to go for review. Then lastly, where you see when it is a consent judgment, the answer is also review. Okay? So are we together? We go on? Let's go for revision. So now, because once we start reading revision, now you are distinguishing between review and revision. Okay? So that facts, when they give you facts, you are able to tell. Okay? Are we together? Let's go. Okay? Section 82. Section 82. It says, section 83, sorry. It says, now, first things first, we have to look at jurisdictions of revision. Section 83 says, the High Court. Now, the first thing where you see, and you say that the answer is revision. Okay? Now, the biggest challenge now, differentiating between revision and the first appeal to the High Court. Okay? But once you see that the judgment on the top has magistrate's court, the answer is either revision or first appeal. So now you see where the challenge is now. Okay? I will review. Review you can now tell. This revision, because the challenge is the court that has the appellant powers from decisions of the magistrate court is the same court with the powers of revision. Now that's where the problem is. Okay? That's where the challenge is. Okay? So we proceed, but we shall tell. Okay? It says, The High Court may call for the record of any case which has been determined under this act by any magistrate's court, and if that court appears to have. Now, the first thing you look at to distinguish is jurisdictions. Now, once they give you the judgment, like this, look at the top where the court was. Okay? They can give you facts of impeachment. They give you judgment of company. Where geographical jurisdictions. You get it? Remember, that can be a ground of appeal, that the trial magistrate had in law and fact where he or she exercised the jurisdictions not vested in him or her under the law, hence coming or hence occasioning a miscarriage of. But the same ground can be a ground of revision. Okay? But the most appropriate would be why they can tell that your client needs a swift remedy. That is another catch-word. Because an appeal, you may lodge it. You know the criteria. Okay? The time of determining an appeal and the time of determining an application are they the same? So now in the facts they can tell that the client wants a swift remedy. Now, you start lowering your pace. Okay, revision is an application. So the time within which it is determined is very little. You get it? So you first underline the word swiftness. Then, after that, once you see that the court had no jurisdictions, don't go for appeal. Go for revision. Because it is the most pertinent ground under revision. There is a decision, but I've never accessed it. I'm looking for it. Okay? But I know it is on that principle. Okay? I don't know the citation, but what I know, it is Lumama Apollo versus Ibrahim Kunowa and others. It was a miscellaneous application arising out of a judgment from Nawe, Chief Magistrate's Court. It was exercising those powers. Okay? But I will get it. Okay? Because I'm looking for it badly. Going to instead. Okay? So let's proceed. Okay? Then it says, 1, determined under this act by any magistrate's court, and if that court appears to 1, exercise jurisdictions not vested in it in law, failed to exercise the jurisdictions not vested, or acted in exercise of its jurisdictions illegally or with material irregularity or injustice. Now, the last ground, which has what we call irregularity or illegality. Okay? That one, when you are dealing with illegality, once something illegal is something that's not allowed under, once you look at jurisdictions, once you exercise the jurisdictions under, not within your mandate, isn't it illegal? So you see how that ground may fit proper for this. Then irregularity comes on procedure. Procedure, irregularity. For example, they will give you facts of attachment and sale of land. Okay? They give you an order. When you look at the procedure, the client tells you, I have the title at home. Okay? Go asome execution your money wamuvako wamukolachi wamuona. Bakwe an order of execution. Okay? You first come to the rules. Is it an order upon which you can appeal? Yes. Okay? Now you ask yourself, where is the problem? But the client tells you, I have the title. You forget that in civil, where you are dealing with attachment and sale of land, the title should be first deposited where? In court. That is a procedure irregularity. The answer will be revision. Okay? You get it? I'm giving you an example of what we call a procedure irregularity. We've said that one, they can give you facts where the client is a party to a suit. He tells you they have given me this order. It is an order of sale of my land. You get it? But I have the title is here. What is the procedure when they are selling land on a court order?
They first take the title.
Court first makes an order depositing the title where? So if this guy has the title, did court follow the right procedure? So that means that's a procedure irregularity. The right answer will be are we together? Now the way the challenge is most of the things people didn't take note of the procedures. That's the challenge. So gojja kukisoma asira bawonsobi wano tewali error, tewali irregularity. Anyway, but just that you are unlucky. What they have given you, okay, you didn't deal with it. Okay. Okay. We proceed. They're saying that the High Court may revise the case and may make such order in it as it thinks fit, but no such power of revision shall be exercised. 1. Unless the parties shall first be given an opportunity of being heard, where from lapse of time or other cause the exercise of the power would involve serious hardship to any person. What does this mean? That an application for revision is not expert. It is not expert. Okay? Let's go to the rules now. Okay? Come on. Okay. Okay. Yeah. Okay, so now let's get the rules. Yes, okay, let's look at order 52. So when you look at let's first look at the MCA, but what is in the MCA is what is in. Should we look at let's first look at the MCA. So orders of grounds we're going to put what of okay, let's look at the MCA. Someone with the MCA. Okay. Let's look at section 221 of the MCA. We are still under revision. 221. Now, revision is on two grounds. We said we have revision by reference and revision by application. What we've looked at first was revision by application. So we have revision by reference. That's the one now we are reading from the MCA. Section 221 says that 221 says supervisory powers of the Chief Magistrate Courts. The Chief Magistrate shall exercise general powers of supervision over all magistrate courts within the area of his or her jurisdictions. Without prejudice to the generality of subsection 1, a Chief Magistrate may call for and examine the record of any proceedings before a magistrate's court inferior to the court which he or she is empowered to hold and situate within the local limits of his or her jurisdictions for purposes of satisfying him or her soul as to the correctness, legality, or propriety of any finding, sentence, decision, judgment, or order recorded or past as to the regularity of any proceedings. Okay? Then, under that, under section 221 subsection 3, okay, the magistrate who has called for the file, and upon examination, he or she realizes that there is an error apparent on the face of, there is an irregularity. Okay, that irregularity that we are, because the other side we saw irregularity as well. So where the magistrate realizes that there is an irregularity, the magistrate has no powers to revise. Then under subsection 3, the magistrate shall refer the file to the High Court for revision. Okay, that is what we call by reference. By reference. Yes, I call. Members online, are we still together? We have numerous authorities that do explain the grounds of. Now, the biggest challenge is understanding what is illegal and what is irregular, because you have to define what amounts to an irregularity. So which case are you well conversant with? Okay. We have many. Okay. This one is very old. Let me look for the new one. Okay, we have the case. It's a recent case. It is LL Samuel versus Eriono Charles. LL Samuel versus Eriono Charles. Revision application number 2 of 2022 in the High Court of Soroti. Yes, of 2022. I've shared it on the platform. I've shared it on the platform. Let me also try to get another case that is a bit easy to pronounce. I know some people are okay with that, those names, but I have people here. Okay. Now, if you want to understand, you can read the case of Cardinal Subuga versus Makula International. In that case, court pointed out what amounts to irregularities. Yes, okay. Then you can also read the case of Opendo Patrick and others versus Chichoncho. High Court Civil Revision number 33 of 2018. Of 2018. The network is a bit slow. I shared the first case. I've also shared this one. Okay, so you will look through them and analyze accordingly. It is criminal revision number 9. I've shared the case, but the cases I've shared, they cite all the cases I've been talking about. So you refer to them for further consumption. How do we apply for revision? Is it by notes of motion, chamber summons, originating? It is by notes of. Why? The civil procedure rules have not expressly provided for the same. As now, package here, appeals. How do you apply for review? Does the order provide? Does order 46 provide? Yes. Okay. Is by notes of motion as well. Now, let's go for appeals. So let's think open. Yes? Okay. Sleep rule it is having only one section. Okay. Let's listen. Yes. They attach the report. Yes. So it is by only that's what called reference. Okay. Then let's look at section 99. Sleep rule. Before we go for appeals, let's look at sleep rule. It says it is okay. Let's look at section 99. It says clerical or mathematical mistakes in judgments, decrees or orders or errors arising in them from any accidental slip or omission may at the time be corrected by the court either on its own motion or on application by any of the parties. When you look at what we call slip rule, that application is only available to parties to a suit. Okay? Only parties to a suit. Okay? Now, nothing do we have on sleep rule apart from that. So it is simple, but I tell you, it's by notes of motion. Okay? But in most cases, people write letters because the mathematical errors happen in writing amount of money. Okay? Figures, block and plot numbers, names of parties, only that. Now, let the party begin. Appeals. Appeals. Now, in everything you're supposed to give your time, give appeals. I know the head subject emphasized it more than I have done because she knows, okay, why it should be dealt with. So, when we are dealing with appeals, first things first, okay, what are the different types of appeals? Okay. Okay. The first thing to determine what type of appeal are you going to deal with. So we have what we call first appeals. First appeals. Under first appeals, we have the following. Okay, we have the following. One, a first appeal to the Chief Magistrate's Court. Where it is emanating from what court? Grade 2. Okay. Then we have a first appeal to the High Court from the Chief Magistrate's Court. A first appeal from Chief Magistrate's Court or Magistrate Grade 1 to the High Court. Then a first appeal from High Court to Court of Appeal. All of those are first appeals. A change out the chili for civil. The appeals nyingi okusinga kuzachi za previous. Then we have a first appeal from a constitutional court to Court of Appeal. A first appeal from constitutional court to Court of Appeal. Now, there is this thing that I don't understand. Where a matter was determined by a single justice, okay, do we appeal or we refer the matter to full bench? Let's assume the matter was supposed to go.
The matter is referred.
Okay, she has appealed to Court of Appeal, and the matter is determined by, because they will give you a judgment of Court of Appeal. Okay, when the matter was determined by a single Court of Appeal, Supreme Court. You get it? You apply to the Supreme Court your appeal as a second or a third appeal, whatever the case may be. Okay? First look at the bench. Was it full? If it wasn't full, that is not an appeal. You go for reference to full bench. Okay? Okay, let's go to second appeal. That's where I'll bring it out. Eh? Yes? That's the second appeal now. Because once a Court of Appeal sits as a constitutional court, a constitutional court is exercising its original jurisdictions. So if you are dissatisfied from the constitutional court, you go to Court of Appeal now. No, remember, a court.
Counsel, from the constitutional court, I thought we go to the Supreme Court.
Yes.
I thought from the constitutional court we go to the Supreme Court because.
Yes. As a court of first instance. LGDP. Okay, let's, and it depends. Remember, a constitutional court also has a panel. You get it? That's the challenge with it. If the panel was full, it becomes an automatic appeal. Okay, so let's go to second appeals. That's how we are going to pick out this. Okay, second appeals. A second appeal is an appeal emanating from a decision of the first appellant court. Okay? If a second appeal is an appeal emanating from a decision of a first appellant court. Okay? One, we have a second appeal to the High Court from the decisions of a Chief Magistrate Court in exercise of its appellant jurisdictions. Okay? A second appeal to the High Court from decisions of the Chief Magistrate Court in exercise of its appellant jurisdictions. So that means the first decision was from grade 2, it went to chief, okay, as an appeal. Then after, it is to High Court, okay. Then another category of a second appeal is an appeal to the Court of Appeal from the High Court in exercise of its appellant jurisdictions. Okay? An appeal to the Court of Appeal from a decision of the High Court in exercise of its appellant jurisdictions. So what does this imply? She filed a matter in the Chief Magistrate Court. She was dissatisfied. She applied to the High Court as the first appellant court. Still, she's not okay with the decision of the High. Then she goes for the second appeal to Court of Appeal. Okay? Then, exactly. Then, a second appeal to the Supreme Court from the decision of a Court of Appeal in its appellant jurisdictions. Okay? A second appeal to the Supreme Court from the decision of the Court of Appeal in exercise of its appellant jurisdictions. Then we have third appeals. Planning outcomes. Okay, so we leave that. Okay. But third appeals, they are to Court of Appeal and Supreme Court. Third appeals. Okay. So they are rare. Let's leave that. So now let's go to what we call principles. So today we are only going to look at first appeals. First appeals. Now, the following, when you are dealing with appeals, okay, this is issue 1. Whether so and so has a right to appeal. Okay, whether so and so has a right to appeal. So let's look at factors that we look at when we are determining a right to appeal. We go on. Let's go to now. Let's start with the Magistrates Act. Magistrate Courts Act. Are we there?
Yes.
Civil appeals. We are dealing with the MCA civil appeals. Okay, so let's go to section 220. So here we are looking at first appeals from magistrate courts. Okay, we are dealing with first appeals from magistrate courts. Okay, says civil appeals subject to any written law and except as provided in this section, no appeal shall, an appeal shall lie from decrees or any part of decrees and from orders of the magistrate's court presided over by the chief magistrate or a magistrate grade 1 in exercise of its original jurisdictions to the high court. Okay, so that means once you open the workshop or the paper and you open and look at the heading when it has magistrate's court, be that as it may be, and you look at it like this, either the answer will be review, okay, revision to the high court, or an appeal to the high court as the first appeal. That's the first determinant factor. Then after that, ask yourself, then I'm interested in those are second appeals. Okay, then subsection 2 says subsection 1 shall have effect notwithstanding anything contained in the Civil Procedure Act or in any rules of court requiring that a decree be done and extracted before an appeal is filed. Then 3 talks about leave. Those are second appeals. Okay. Then when you look at section 220, subsection 5, okay, it says no appeal shall lie from a decree passed or from a decision, judgment, or order given or made as a result of consent. So the first rule in determining whether a party has a right of appeal is on consent judgments. So that implies that where you see that the judgment is a consent judgment, you don't have a right to appeal. Okay? Within what time do we lodge an appeal? Yes? So we've seen the first factor upon which we determine that a party has a right to appeal. Okay, let's open section 70. Let's open section 76. Section 76. It says, an appeal shall lie from the following orders, and except otherwise provided by this act or by any law for the time being in force, from no other orders. What does this mean? The orders listed under section 76. Once you see an order on the following, you have an automatic right to mark that. But if the order doesn't fall within section 76, okay, you don't have the right to. So once they give you a question and you see the order, first ascertain, is this an order on which you can appeal before you say you're going to appeal? Okay, we are looking at section 76, which says that appeals from orders. So once you are given a set of facts and they have given you a copy of the order, first ascertain whether that order is appealable. Are we together? Okay, whether that order is appealable. So section 76 says orders from which appeals lie. This implies that the orders listed under section 76, you have a right to appeal. Are we together? Okay, we've said the first factor you look at and you say that this person has a right of appeal is consent. So if the judgment attached or an order attached doesn't emanate from a consent matter, you have a right to, that's the presumption. Then after, look at the order attached. Is this order an order under which we can appeal? Because you may rush to check the time, you get it, and you are within time, but the order that has been attached is not appeal. I have the right to appeal. You do an appeal. Yet the order, you can't appeal against it. So section 76 says, orders from which appeals lie. You know very well. We have, which famous case you guys know in Philip that talks about appeals? That case has two principles. That one, an appeal is a creature of a statute. Automatically, this section creates a right to appeal. So where you don't have a right to appeal under the statute, you have to seek for leave of. So that's why whenever you're dealing with appeals, the first thing to determine is you have a right to appeal. Okay? So it says, an appeal shall lie from the following orders, and except otherwise expressly provided in this act or by any law for the time being in force, from no other, it is expressed that if the order is not within these orders, you don't have a right to. One, an order superseding an arbitration where the award has not been completed within the period allowed by court. Then an order on an award stated in the form of special cases, modifying collections of the award, etc. Now, on top of these orders, then you open the civil procedure. Okay? Then you open the civil procedure, because you know these guys are wise. They know. Ask the family of someone. Okay? So they don't give these ones under. They don't. Okay? Now, when you read section 76, subsection 1, paragraph 8, it says, any order made under the rules from which an appeal is expressly allowed by the rules. So that age sends us the civil procedure rules. So what rules? Where we have an automatic right to appeal. Okay? Then we go to order 44, which says appeals from orders. It says an appeal shall lie as of right. So that means the act has given you an automatic right to appeal. So it says an appeal shall lie as of right the following orders under section 76. So when you see that, you read all these orders, okay, so that you get to know. Now, where the challenge is, you people don't know these orders. Now, if I say that one, an order made under Rule 8, there is a common one that I'm interested in. We have an order made under Rule 19 of Order 16. Okay, we have an order that execution will be levied made under Rule 6 of Order 23. An order made under Rule 8 of Order 24, refusing to set aside a dismissal order. Okay, you might agree. They give what the most ones that I've always seen. One, setting aside a default judgment, amendment of pleadings, and then this one I've just mentioned, setting aside a dismissal order. Okay, then an order made under Rule 10 of Order 15. Then an order made under Rule 27, okay, of Order 9, rejecting an application to set aside a decree passed ex parte. Once you see that this person made an application to set aside a default judgment, okay, to set aside a consent judgment, to set aside an ex parte, and it wasn't granted, you automatically have a right to. That is the first determinant factor. But the challenge is, you people have a challenge of understanding the orders under this, that orders they are referring to. Most of you had issues with reading these Roman numerals. You see, in our year, in the exam, okay, I sat in the auditorium. It was civil. Abanganchimanyi no yetaga method for the proceedings lwaki bw'otuula wekka kyangu nnyo okukola review oba revision appeal nga togirabye otuule wano. So I came in the auditorium mu corridors omwe twali osobola okusitula yokatebo with the seat n'oteeka mu corridor nenzija ne mbaako weeteeka. Oh, you know, an alien can be seen. Sit down, come. Natafuto yanga nabategwayo. Namanyi bate ku podium maso. Nanze soka. I swear nasirike nenga mukama Katonda. Yonna decision ngenda okukola oba ngenda kukola review oba revision oba appeal yamba. Nga mu maaso w'otudde n'okukyusa bw'otyo oba owulira oswala jjukira waggulu yonna bakola ki? Nenga mukama kankole kyonna kyenkola ki? Baleeta paper bwe bati okubikkula nga it is an order. Nengamba ekijja kijje sigenda tunawakola apiiru bwe nalaba order nensoma that this matter is coming down for final dispose on this date and this application was brought under order this and this. Nezija wati ngenda okulaba order gye bamention eri wano mu 44 nengamba kale wallahi ning'oba oyagala nnyo newonkoona kola mbiiri sivaawo. I swear never sivaawo. You know, people are lenient. Someone passed through Nagam. The 44 deals from orders. Yes. 44. Then the number 44. Going up. What is the gear? Then after the paper, people went ask counsel, blank my hand, counsel. Reveal the day that. That's what I was. What is the right of appeal? Yes. How appeal coming? Oh, I never heard of one people appeals from orders. Now, automatically, I will appeals from orders. Na never ever take appeals. I never take an order. So can you? Morgana, yeah. What was you feel okay? So once you open the paper and it is an order, first come to order 44 before you start writing to determine whether that order is appealable. Where it is not appealable, you have to make an application. Because the order is very clear, order 44, okay? Order 44. Now, even an order made on interlocutory matter by the registrar, that is consolidation, test suits, amendment of pleadings, all of those are interlocutory, so you can appeal. Okay? You get it? You can appeal. Then what is spirit go. Okay? So, now, when you read Order 44, Rule 2, it says, an appeal made under these rules shall not lie from any other order except with leave of court making the order or the court on which an appeal would lie if leave were granted. So what does this mean? Once you read the order and it does not fall under the orders under Rule Order 44, you need leave of court to appeal. And go in exam. I presume because the application is but the reason was so we will proceed now. After that, okay, after that, we come back to the Civil Procedure Act. So another mode to determine whether you have a right to appeal is time. Is time. Is time. So you see, we've so far seen two circumstances. Now this is the third one. Section 79. It says 79 of the Civil Procedure Act. It says, except as otherwise specifically provided in any other law. My people, musome nnyo akagambako any other law. Ogenda genda mu paper olenga answer appeal. Okay? But because you read this law, you know 30 days. Except as provided by any other, you know that we have other laws that have time zone of appeals which is different. Think of that matter. For example, you did civil, not so? Did you look at procurement? Yeah, that court has different jurisdictions and time zones of determining human rights matters, electoral petitions. So you may forget that word. No to come with paper. Never question when it is emanating from another law other than the Civil Procedure. Or no kubera so sober on appeals because it says except as provided. So once you see judgment, ask yourself, this judgment is emanating from what matter? Okay, because we have matters which with different time zones, and the laws are provided. Look at employment matters. Okay, you forget that civil is corporate and commercial. Corporate and commercial is civil. So, by virtue of this, be so keen with the decision before you. Okay. We proceed. Okay. What do you see? Every day we see what you don't. You don't know. But if you have paper and the clear, nyo wala ngolaba nyam noga. Mpadde bati ekirabwako bweki. Where is the problem? Ngolaba, the order is appealable, everything is appealable. But there's nowhere the matter emanates from. Ejja kuba in a different time zone. Ojja ogwe mu time zone okozesa eno act eba 30 ngoba tolina right of appeal. You get it? So be so keen. Bajja kuwa electoral petition. Ogirabe words. The reason why it's called specialized proceedings, because time zones are unique. Mark that. Okay. So it says, except as otherwise specifically provided in any other law, every appeal shall be entered within 30 days of the date of the decree or order of court, or within 7 days of the date or order of the registrar, in case, as the case may be, appealed against, but the appellant court may for good cause. Now, I want us to look at this. Once again, you are given an order of a registrar, an order, you appeal to the judge. You appeal to the judge, but within 7 days. This will first open what you see the decision was by who before you rush with the time. If you see that because they may give you, for example, we have contempt of court. That application is heard by the registrar, not so. What if it is determined by the registrar and the other party is not contented with the decision? You see, when you wait for 30 days, okay, they can also give you a temporary injunction, which is single-sided, which says that a temporary injunction doth issue restraining the respondents, and they tell you are representing the respondents. Are you going to go for review? You appeal against that order to the mark that. Okay. So you look at those. Okay. So we proceed. Then, in computing the period of limitation prescribed by this section, the time taken by court or by the registrar in making a copy of the decree or order appealed against of the proceedings upon which is founded shall be excluded. Okay. Now, what orders do you pray for in appeal? So you just look at section 80, powers of the appellant court. Now, we say we have a right to appeal, not so? Now, once you have a right of appeal, the next step will be commencing, coming up with the grounds of it is there, but me, I don't look at that. because forget extension of time. The section we've just read, section 90, section 79 handles that very well. Okay. So now it's where the challenge is. There is none that prescribes grounds of appeal. But let's come back. I want to go on. I want you guys to take time okay. Look at section 72. Okay, it says I'm just speaking something. Eh? No, I've just said that the orders you should seek for, it's just clear, okay? But I want you to look at section 67, 68, okay? 67 and 68. When you look at the reason why I'm not citing 66. There's the law that creates appeals to the court of appeal. Eh? But when you look at the title, it says appeals from original decrees. What does this mean? Original decrees means decisions of court in exercise of its original jurisdictions. So those are what we call first appeals. When you read the sections I've told you, first appeals, you appeal against matters of law and matters of fact. On first appeals, doesn't matter which category of first appeal, but you have a right to appeal against matters of law and matters of fact. Differentiate matters of law and matters of fact. How do you tell that this is a matter of law?
The law might certain acts. For example, it can uphold and confer jurisdiction upon particular court.
That is a matter of. Then matters of fact emanate from evidence.
Yes.
Okay. Yes. Yes. Okay. So are we together? Now, when it comes to second appeals, but this workshop is not on second, workshop 1 is not on second appeals. Okay. And I think you guys, you don't have second appeals in your workshop. It's all a second workshop. I think it's on first appeals. First appeals to court of appeal. Okay, so you don't have second, but you have to read them. Second appeals under section 72. Second appeals, they are restricted on only matters of law. Only matters of law. Under section 72. Then third appeals under section 73. they are only restricted on matters of great public importance. So now, second appeals on matters of law, third appeals on matters of great public. Let's get our workshops now. 72. Someone told me the workshop. I didn't carry mine. Please sit near the workshop, please. Okay? I know workshops are scarce. Okay. Okay. So at least sit with a neighbor who has a workshop, okay? Now you should let the gentleman sit in between. And you balance the both of the workshop. Huh? Hey, you hold the workshop. Yes, he did. Okay, so we go on. Now, after reading the law, see, in a season, yes, that day, so enough fun, okay? We've read the law. Now, you ask yourself, before even you read the facts, now we are going to apply the law we've read on our facts, okay? That's how you're going to tell kana kantu temuli okasoma dakika 10. You get it? Okay, so now let us read the learning outcomes of workshop 1. Sleep rule, section 99. Okay, so it says workshop 1. The workshop is on post-judgment practice. One thing we've not looked at is stay of execution pending appeal. Then stay of execution pending revision and review. Okay? But everything is post-banner section 98. Okay? So it says the workshop is on post-judgment practice arising out of decisions of magistrate grade 1 and chief magistrates. It thus focuses on remedies of review, revision, amendment of judgments, and appeals to the High Court. It introduces the students to interlocutory remedies available to an aggrieved party in order to preserve the identified post-judgment remedy. Okay? Okay. Learning outcomes. So the learning outcomes we are reading, when you do so much, even before we read the workshop, ask yourself, have you at least achieved the part of that learning outcome? Can you say something on that learning outcome? Okay. Says, explain the various principles regarding revision, review, amendment of judgments, and appeals to the High Court. Now, from that, if the law becomes sub-educate us on review, can you educate us on revision, educate us on amendment, educate us on appeals to the High, first appeals to the High Court from decisions of T1 and Chief. Can you say something? Yes. Can you identify? That shows that at least you have an idea on the learning outcome. Okay? Then they call presenting applications for revision, review, and amendment of judgments and appeals. That's what we call making the submission. Okay? Well, now, this means you know the grounds of review and the grounds of revision, and you can formulate grounds of appeal. That is the presumption. You know the circumstances under which you can apply for amendment of judgments. And if they say that add that ground, you can. That's what we call presenting. Then present an application for stay of execution pending post-judgment Okay, we are back. We said that our third learning outcome is to present an application for stay of execution pending post-judgment remedies. Now, these are simplest things. Have you ever seen any rule or any section that talks about stay of execution pending revision or pending review? That is section 98 of the Civil Procedure Act, section 33 of the Judicature Act, and order 52. Automatically, those are the only laws. But only which has a static law is stay of execution pending appeal. That one has the law. Okay? Are we together? Then to draft the documents. Draft documents. Then recognizing ethical issues. Someone asked me counsel. No, So now let's deal with facts of workshop 1. It says, part A. Assume that you are a legal assistant at MS Mushan and Company Advocates, Plot 3, Kampala. Mr. Mzungu Edward is seeking legal advice. He tells you he is not happy with the decision he got from court. He hands over the ruling. You underline the what? Ruling. Okay? To you with the tenants' agreement. That is appendix 1 and 2. We go to the same. Okay? In the Chief Magistrate Court of Makindye, sitting at Makindye, miscellaneous cause number 63 of 6/7 of 2023. Okay, an application for distress for rent. Mugezi Bright and Muzungu Edwards. Okay, are we together? It says distress for rent. His Worship Susan Mwanga, Chief Magistrate. Tenants terminate or tenant gives notice. Then preliminary objection. It is on what?
Jurisdiction.
Underline that.
And arbitration.
Then and arbitration.
No clause.
Before you read anything, what comes into your mind?
Arbitration.
What is the effect of an arbitration clause? If it is, so that means the matter, the court had no.
So it is the procedure.
Counsel, pardon on that page.
Hold on a bit, colleagues.
Anyone who knows the page, kindly type in the chat box.
Anyone who knows the page?
The page.
The compressed workshop from Henry is page 5.
Some workshops is page 7, others page 9, so it's a case-to-case basis. Okay?
Yes, the compressed workshop from Henry is reading page 5. Now we're on 6.
Yes, the compressed one shows files. Okay? So now, but I want you to look at this. Okay? An appeal shall die from the following orders and except as otherwise expressly provided. Okay, so we shall get there. Okay, so let's go on. So let's read. It says introduction. The applicant filed this application under the Distress for Rent Reliefs Act, seeking for orders that a special certificate be issued by this court to enable the applicant to recover rent areas from the respondent. An order of sale of the respondent's property held in the premises to recover the rent areas in order, and an order of vacant possession and costs. Okay. Background. Okay. The applicant and the respondent entered into a tenancy agreement for rent of the premises for a period of 19 years from the 10th of April 2015 to 9th of April 2034 at the rental sum of 900. The parties further agreed that the respondent would pay the sum of 300 to the landlord applicant and a sum of 600 would be retained by the respondent, the tenant, and applied to the labor stock development she incurs on the tenant's property. That in April 2017, the respondent deliberately withheld or neglected to make payments of 49 million, hence this application. Okay? 49 million. Okay? Look at those jurisdictions first.
It's okay. Let's look at refinery.
Okay, again, mass. So, is the issue of jurisdictions okay?
Yes.
First, wait, who am I representing? Muzungu was who? Was?
The respondent.
Okay. Let's proceed. Okay, it says the application. The application was supported by an affidavit deposed by the applicant, Mugezi Bright, premised on the following grounds: that the respondent owes the applicant a sum of 49 million in outstanding, that is the interest of justice, that the certificate issued, that the application was proposed through the affidavit in reply by Muzungu Edward, that the applicant got a motor accident where she was bedridden for 3 years, and on her partial recovery, she sublet part of the premises. That the applicant and the respondent agreed that upon termination of the tenants' agreement, either party was obliged to give written notice of 6 months. That during the course of the tenants, the respondent made renovations, improvements, and developments, and part of the rent payable to the applicant went to cover those developments. That the disagreement relates the amount owed to the applicant at the time of the demand notice. That based on the report of an accountant appointed by the respondent owes the applicant 31,226,500, and the respondent has a counterclaim for developments, innovations, and repairs of 196 of 196. So the counterclaim brings the issue of okay. Let's proceed. Submissions of counsel. Whether the applicant is competent is for distress, for rent. So that means they raised 2 issues for determination. Okay. The second issue is what remedies are available to the parties. For the applicant, it submitted that distress is a right vested in the landlord as against the tenant in the lease or tenants agreement to seize the tenant's chattels so as to recover the unpaid rent, that the applicant must show the existence of the landlord-tenant relationship. Counsel cited that case. Counsel for the applicant further submitted that the fact that there exists a landlord-tenant relationship has not been disputed. By the respondent, and the sum of 49 is owed in rent by the respondent to the applicant, and the respondent admits indebtedness to the applicant. In reply, the respondent raised the preliminary objection that this court is not closed with the jurisdictions to entertain this matter. The PO is comprised of 3 limbs. The first one is that the court has no jurisdiction to entertain the matter over above its pecuniary jurisdictions. Counsel for the respondent submitted that when the applicant's lawyers made the demand for rent of arrears, it was a sum of 51,300,000, and that the applicant sought to circumvent the pecuniary jurisdictions of the chief magistrate by making a deduction to 49 in her pleadings. Section 207 of the MCA relied on and referred to Gen G versus Shah, Ozu Brothers versus Mirika Oyukuru, where also cited the position that jurisdiction is the creature of a statute, and that where the court takes 20 upon itself to exercise
Takes it upon itself.
okay, and then proceed. Takes upon itself to exercise jurisdictions which does not possess, its decision amounts to nothing. The second limb relates to arbitration clause in the tenancy agreement. Counsel for the respondent submitted that this court is not possessed with the jurisdictions to determine this matter on account of arbitration clause, and that the same should be referred for arbitration as agreed and contemplated by the parties in the tenancy agreement. Counsel cited clause 6 of the tenancy agreement. First, go to the tenancy agreement.
Yes, in any case,
Okay, it says, in any case of any disagreement, so as the terms of this agreement, the parties shall seek, underline the word shall. Yes, in clause 6. What does that indicate?
mandatory.
Is mandatory. Okay. So, what did court say? We go back now.
There's so many disagreements.
Okay. So now, counsel relied on the case of vintage mezzanine fund. Okay. Counsel relied on the case of vintage mezzanine fund 2 partnership versus Timber Properties Investments Company Limited and another, for the position that before a matter is submitted to an arbitral tribunal, there must be a valid and enforceable arbitration agreement. An extant dispute between the parties before court, and that the court has no jurisdictions to hear the matter. Court has no jurisdictions to hear the matter. Okay. Counsel prayed for permanent stay of the suit and or its dismissal with costs. In rejoinder, it was submitted the applicant the claim before court is 49, which is within the jurisdictions. In regards to the arbitration clause, it was rejoined for the applicant that arbitration as it means of a dispute resolution cannot be raised where the arbitration agreement is null and void. That is to say, it is incapable of being performed. Counsel submitted that there was no fundamental breach.
There was.
Counsel submitted that there was a fundamental breach of the tenancy agreement when the respondent defaulted on rent for 5 years, thereby giving the landlord a right to re-enter. It was counsel's submission that the respondent admitted liability, and that where a party has admitted liability or compromised his or her standard by some admission capable of altering the position of the parties, the matter can no longer be referred to arbitration. Cited the case of Simba Investment Properties Company Limited versus Robert Chirunda and others. Know that this is the same matter they're referring to, Simba Group of Companies. Okay? Analysis. I have carefully considered the submissions of both counsel. The claim was of 49, which is within the jurisdiction of regard. Then in regards to the second leave, Section 2B of the Arbitration and Conciliation Act defines arbitration to mean any arbitration, whether or not administered by a domestic or international institution, where there is an arbitration agreement. While an arbitration agreement is defined under paragraph C to mean an agreement by the parties to submit to arbitration or all or certain disputes which have arisen or which may arise between them in respect of the defined legal relationship. The form of arbitration agreement may take it provided under Section 3. An arbitration agreement may be in the form of an arbitration clause. The law regarding stay of legal proceedings in court of law is captured under Section 5 of the Arbitration Act and Reconciliation. Okay? Okay? Okay. Says, okay, a judge or magistrate before whom proceedings are being brought in the matter which is subject to arbitration agreement shall, if the party so applies after filing of the statement of defense and both parties having been given a hearing, refer the matter back to the arbitration unless he or she finds that the arbitration agreement is null and void, inoperative, or incapable of being performed, or that there is not in any fact any dispute between the parties with regard to the matters agreed to be referred to arbitration. Okay? Subsection 2 provides that notwithstanding that an application has been brought under subsection 1 and the matter is pending before court, arbitral proceedings may be commenced or continued and an arbitral award may be made. Okay? Now, from the wording of section 5, it is clear that where there is a matter before court that is subject to arbitration, court shall refer back such a matter for arbitration unless such agreement is unenforceable. I am wholly in agreement with the binding decision of Vintage, rightly cited by counsel for the respondent on the condition to be met by the applicant. In the present matter before court, the contract was executed between the parties on the 9th day of that for the rent of premises, and the same agreement, an arbitration clause captured under clause 6 as this. Counsel for the applicant submitted that the respondent put herself outside the ambities of the protection of the clause when she absconded from attending a meeting organized by the applicant, and that the instance of arbitration and afterthought. With due respect, I disagree with the submission of counsel for the applicant as regards to arbitration. All the necessary conditions for referring this matter for an arbitration are available, and the counsel submissions that fundamental breach the respondent amounts to what constitutes invalidity. However, the twist in this application can be traced under paragraph 11, 1930, but particularly paragraph 19, where the respondent admits indebtedness to the applicant, to a tune of 31. The holding of His Worship Justice Stephen Mubiru in Simba versus Lunda, as rightly cited by counsel for the applicant, is very instructive. In the instant application, the respondent's contention is not that she denies being in arrears of rent, but rather the amount owed to the landlord, and according to her arrears, according to her professional accountant, she is that it is my view that the amount admitted by the respondent is no longer subject to negotiation, and such as arbitration over it is not feasible. Lastly, regards to the third limb of the objection, I am of the considered view that the matter in this suit, yes, it is in the interest of justice that the amount admitted be paid to the applicant henceforth. Okay. Lastly, that as regards to the third limb of the PO, I am of the considered view that the matters in this suit and those in the High Court are substantially different, and the respondent has not made out a compelling case to the satisfaction of this court warranting stay of proceedings. In the final result, I make the following orders. The respondent pay that money. The dispute remains of 17. Matters relating to vacant possession sale and the costs are stayed pending the result of the arbitration and the outcome of High Court. The Sinners cause number that obiter dicta. This court shall not make any pronouncements in regards to eviction. The agreement between the parties under clause 7 read together with clause 8 would permit the landlord to re-enter the promise upon failure to pay of rent over 1 year. Over 1 year. Okay. From the reading of clauses 7 and 8, the tenants' agreement, and bearing in mind the law as it is, I don't think the landlord in such a case requires the permission of court to re-enter. Now, is it an appeal? Is it review? Is it revision? Yes? War. That's which era? War. Hey, war. That's what are the grounds of review. That's how we are going to determine the answer. Do you have any new evidence apparent on the face of the record? Which other ground is there for review? Mistake on apparent. Which mistake have you seen? Does review apply? We proceed. Let's go for revision. What are the grounds of revision? That the court exercised jurisdictions not within its powers. Irregularities and illegalities. Okay? Did court exercise the right jurisdictions? Okay, members, first wait. Okay, first wait. You have a right to appeal. Look at the date. When was the judgment, the ruling delivered? 2020. Do you have time? What remedy is available? Sorted. Huh?
Under any other sufficient cause that what jurisdiction can call them.
It can, but now here look at the date. Okay, within what time can you break? Yes. No, appeal. Okay. Appeal within 30 days. So 30 days have expired. Now outrule appeal. Okay. Let's stay with the review and revision. Okay. So now the first ground for review is discovery of new and important evidence. Do you have any? You cancel that. Go to the second ground. Is mistake or an error apparent in the face of? You see any error? Okay, so you put us on that. What other ground? Any other sufficient cause? Okay, any other sufficient? The sufficient cause that you could rely on. This guy raised the matter that he got an accident. Court didn't consider. So that means you can't go back with the same reason before the same. You get it? Now let's go to revisions. What are the grounds of revision? Exercising wrong jurisdictions. Now, what is the appropriate answer? The answer is revision. Let's go to part B of the question. It's how you break it. Okay? So that means for you to get the right answer, you should have made all the three remedies.
Counsel, please put the appropriate answer.
You're going to look at the counterclaim itself, change jurisdictions. Okay? You get it? Even the arbitration clause was very clear. Okay? Why? That matter had a substantial dispute. The reason for the failure, for example, okay? Let's first go back to the argument. Let's go to the argument. Okay. You know what I was looking for in this argument? Yes? I was looking for cost. It's not there. Okay? Because the accident is an actual cause. So it is a sufficient reason because this person, regardless of the fact that he did not pay, he has a valid reason. You get it? So upon that, court can revise that decision. Okay?
This matter had to go for arbitration first when he said matters relating to vacant possession, sale of the respondent's property, and costs are stayed pending the result of arbitration.
Okay.
Don't you think?
But she had already determined the matter. So what were they going to determine?
So when
for
a
arbitration.
so when a PA is raised, it is dealt with.
Okay. So
there are no questions.
okay. So together. Let's go to part B. Yes? The answer is revision in part A. Let's go back to part B. Part B says, assume that just after Mzong Edward left your office, a one-to-one schedule is entered and seeking for legal advice. Step. Pending revision. Okay. Steps to be taken to avoid payment of the disputed sum is step of execution pending revision. Okay. You wait tomorrow. You will see. Let's go to B. A one-to-many entity seeking for legal advice. What did she do? She tells you that she was at the farm located in Mitiana. Her friend,
Sure.
she tells you that as she was at the farm located in Mitiana, her friend Eden Chohaire, a court clerk to Muvende court, came to visit her and share with her something urgent. Okay? Something urgent. Whom are you representing? No. To message. Underline to message. Okay? She tells you that her friend Eden gave her a sealed copy of a consent judgment from Muvende High Court. Underline consent judgment and then Muvende High Court. First stop there. Once you see High Court, okay? You get it? High Court. And then consent judgment. Okay? Rule out appeal. You get it? Rule out appeal. We are remaining with review and revision. Whom are we representing? So they have said that even we don't want to read so much. They have said a copy of the consent judgment is, first go to the consent judgment, is appendix. Okay. Look at the consent judgment. Is your client a party?
No.
Is your client a party? So your client is who? A third party. Now we've said we are remaining with two remedies. We've said review and revision. Okay? You get it? Which remedy is available to a third party?
Review.
So part B is don't even do something much. Okay? Now, it's how things can be simple.
Yes. When they're all together.
Until IA.
And it starts operating relatively.
We need to read any part on part B. Let's go to part C. Part C, okay? Part C says that just as we are about to go for lunch break, the one Zahara Chiwanuka also walks into your chambers. She believes that she is in the right. She believes she is the rightful owner of the suit land, and so she is not satisfied with it. What does that mean? She's an aggrieved party. Okay? Upon paying your instruction fees, she shares a judgment and proceedings from court. Underline judgment and On the remedies we have, which remedy requires proceedings?
Appeal.
So what is the answer on C?
Appeal.
Now first go to the judgments.
Yes.
We want now to determine which appeal.
Judgment.
Is it a first appeal, a second appeal, a third appeal?
5 and
Yes? Interim. Read it out.
What steps should you take if you cancel for the beneficiary to be a prepare about but I think it should be but
Read the orders. First read the orders, the consent judgment. Okay?
so what?
It is stay of execution. There is an order of subdivision. Your client bought, she shared with you a sale agreement. You get it? Your client bought part of that land. Not so? So, but there is an order of subdivision. So her land is going to be subdivided. You get it? So you have to stay the subdivision. That is stay of execution pending. Yes. So let's go to the judgment, which is 5. It says, the Republic of Uganda, in the High Court of the Republic of Uganda, in the Chief Magistrate's Court. First underline, Chief Magistrate's Court. Once you see this, it means it is a first appeal from the Chief Magistrate Court to High Court. Okay? But after that, ask yourself, do we have a right to appeal? Okay? Do you have a right to appeal? Look at the time, 20th of May. Now, you see how it is simple. So here you have an automatic right to appeal.
Yeah.
You have time. Okay? Segment I'm reading. Okay. So look at the procedure. Okay. This is part of this. Okay, so we are still within time. Now, where are the parties starting from? Grounds of appeal. Grounds of appeal. Okay?
We also have read the judgment.
We have to read this judgment.
Counsel,
Yes?
about the date of judgment, are you looking at the appendix 5 or
5. 5 is 4th day of June. It's the judgment.
it's the one you've considered?
Yes, 4th of June 2024. So if it is 4th of June, it is so recent. We are still within time. So that means we have a right to appeal. Okay?
Okay.
Okay. Let's read the judgment. The plaintiff filed this case against the defendants jointly and severally, seeking for an order of vacant possession, declaration of sale of Chivanja holding at liaison by the first defendant to the second defendant was null and void. A declaration that the suit land belongs to the plaintiff and the second defendant is a trespasser on the land. General damages for trespass, costs of the suit. Their claims were denied by the defendants. At the scheduled conference, the following issues. 1. Whether the defendants are trespassers on the suit chibanjo. Whether there are any remedies. Evidence. The plaintiff alleged that she entered into an agreement with her grandmother, Hafswa, a practicing traditional herbalist, to take over her practice in 2011. So she purchased the disputed land and the items of trade for 600,000, which she paid in installments. The final agreement was written down upon completion on the 4th of July. It is exhibited. But after the Dua celebrations following Hafswa's death, where no heir was appointed to her estate, the first defendant assumed office of the heir and sold the portion the plaintiff bought to the second defendant. The second defendant then destroyed the plaintiff's fence and took over the land. Now she cannot practice as an herbalist and earn a living without the shrine. Her witness, PW3, agreed with her that part of the purchase price was paid through him. Okay? Not interested in that. Look, come at Locus. Okay? At Locus, the disputed land covered the northern part of the land inherited by DW1. Thereon sat a latrine belonging to a Wanjuma, a neighbor on the east. Both parties claimed crops on the disputed land. Submissions. The plaintiff's counsel referred the case of Sheikh Mohammed Luwawa versus Chitara Enterprises, where Justice Chawesa stated that these things must be established to prove trespass, that the disputed land belongs to the plaintiff, B, that the defendant entered upon it, C, that entry was unlawfully and that it was made without permission of, or that the defendant had no claim of right of interest. Okay, now I want you to look at the evidence. Okay, you come. I don't know no, where they say that the will. Go to issue 1. Issue 1 says, okay, says, now from the evidence I have labored to relay above, it is noticeable that both parties, that is the plaintiff and the defendant, claim they derived their ownership from the late Hafswa based on the documents allegedly executed by her. One basis on a land sale agreement, Exhibit 1, and the other Exhibit 2, the Exhibit 2, defendant exhibit. Okay? The will. The sale agreement does not bear the signature or thumbprint. It simply records the nature of the transaction in writing, while the will goes a step further, bearing her thumbprint. This thumbprint was not proved by eyewitnesses, okay, or expert evidence to belong to her, and therefore the document may easily fall subject to similar doubt I have raised in the sale agreement. So what does that mean? Okay, the evidence we have is which type of evidence? Is documentary evidence. Okay, you get it? The rules governing authenticity of documents, you know them. And there is that part, authenticity as to documents. Okay, so now that means this matter was determined based on documentary. So all your efforts should be now on evidence. So that means the ground you have is on. So you want to see, because the trial magistrate has shown the weakness of each and every document. So now we want to see how did the trial magistrate conclude on those two documents. Okay. Then, however, the nature of its execution at least resembles another undisputed sale argument of the portion of the land by the late Hafswa. That is the sale to Juma. Okay? So then ask yourself, where documents are, there is a context that is in dispute. Okay? Where two documents are in dispute in regards to handwritings, how do we deal with that? Expert. We proceed. Remember, they wrote the third document that was executed by the deceased. So those three documents would be taken for sample. So now you go on. Where the thumbprint, where she thumbprinted, unlike the alleged sale to the plaintiff, so it is probable she executed the will based on similar conduct of thumbprinting documents. Then the sale argument to the plaintiff that no one endorsed, and when and where it was entered into is not clear. For whereas the plaintiff says it was in 2010 in railway zone, her witness PW3 alleges otherwise. He says in cross-examination that the late Hafsa sent him to pick part of the purchase price from the plaintiff. So how could the argument have been concluded prior the railway zone where she formerly was in her absence? Knowing that the plaintiff emphatically claims it was only written down upon full payment of the purchase price, definitely this is unlikely. The will, on the other hand, bears more credibility. None of the direct beneficiaries, the deceased's own daughters, objected to it. Now, since the will was written on the 3rd of July 2010, by what time the plaintiff had already started paying the disputed land. For PW3 claims that he delivered part of the money to the land in 2009. One would think that the late, if she indeed sold, would have executed the portion from the will, or at least made mention on the ongoing payments for it. The fact that it is not mentioned in a document that is not ongoing, okay, it is further evidence that there was no sale to the plaintiff. So whether the first defendant was never installed as a late Hafsa's customary heir and yet went ahead and sold the disputed portion, the second defendant is completely immaterial. The bottom line is the land was never sold to the plaintiff. So that is like this, so according to you, what ground of appeal do you have? Yes, the trial magistrate had in law and fact when he failed to properly evaluate evidence on record, hence occasioning or hence coming to a wrong decision. If not, you can say that the trial magistrate had in law and fact when she misdirected herself on the law regarding
Documentary activities.
don't be so much on documentary.
Expert opinion.
That this evidence was full of contradictions, which needed to be proved by an expert. You get it? Okay.
When she based on evidence full of contradiction, what needed to be proved.
Okay. So it just depends on the art of telling. But what you should know, the answer relies on failure to conduct expert to refer the matter for handwriting expert. Or you can say that the trial magistrate had in law and fact when she held that the will was validly executed, okay, having a similar handwriting with another cell argument without referring the cell to handwriting experts, hence occasioning miscarriage of. Because you have to hit what you want, you have to capture it in your ground. Okay? So that when you come to the Evidence Act, now that's why the problem is going back. You have to come, you read the Evidence Act. Because it shows under what circumstances can court refer a matter for handwriting experts. And you don't want to be at that Evidence Act. So simple. The facts have only one ground. That is workshop 1. Has another part? Now, in regards to the workshop. Oh, yes. Now, first we have a bit of the landlord and tenant. Which I will repeat that. Depends how you want to take it on. But all what you should know as the landlord and tenant act basically refers on the tenants argument. What you guys have in the tenants argument, this act puts him as power. You see it? Okay. So you see how the workshop is safe, now imagine on Friday. So in whatever reading you're going to make, okay, do it thinking of Friday. Okay. Wa alaikum assalam wa rahmatullahi wa barakatuh. So colleagues, let me wish you the best of luck, and the good Lord bless you, grant you knowledge, wisdom, and understanding. Baba.